So when you're looking at discrimination, there's 4 ways in which that can happen. The most obvious and easy to understand is direct discrimination. So it's very easy to understand that if you fail to give Mary a job because she's a woman, that's obviously direct sex discrimination. There's no justification to that unless we're talking about age. So it might be possible to justify retiring someone when they reach a certain age if you have an objective justification. So I'll talk about that when I talk about indirect discrimination. So indirect discrimination happens when an employer has a provisional criteria or practice, a PCP, which has the effect of putting a particular group of employees at a disadvantage because of their protected characteristic. So a classic example, you've got an employer who introduces a special bonus for employees who work during nights. Now that places women at a particular disadvantage because women mostly carry childcare responsibilities and are less able to work at night. So a claim was brought by a group of women for exactly this situation. But it involved the police. So whilst the starting position was that practice was indirectly discriminatory, the police said, but we have an objective justification. Our aim in introducing this bonus is to reward police officers who work nights. So night work is particularly onerous and difficult, and it's also a particularly dangerous shift for police to work. So it's our aim to reward police who work nights. And it's proportionate offering a bonus. It was only a small bonus. It worked out to about £750 a year. And eventually the court agreed. So it went to EAT, and the EAT agreed, yes, that is a proportionate means of achieving the legitimate aim of rewarding night work. So although it was indirect discrimination, it was justified, and those claims failed. Harassment, I've put the definition up there of harassment. And what's really important to examine when you're looking at harassment is that it's conduct with the purpose or effect. So even if someone does something but they didn't mean it to have a certain effect, it might still be harassment. So your classic example might use what people describe as banter. Well, it's only banter, I don't mean to offend anyone, it's fine. It's not necessarily fine if it creates an intimidating or hostile workplace. And secondly, is the effect. So if it has the effect of creating that workplace, no matter other way around, if it doesn't have this, if no one is offended, but it was meant to offend people, that could still be harassment. So to give you a practical example, I worked somewhere many years ago, nothing to do with law. I worked somewhere where the office was predominantly women, and there was a workshop part of the business that was exclusively men that worked in the workshop. And the women in the office would frequently have to go into the workshop. And in the workshop, the men would every day put that day's page 3 up on the wall in a very obvious place because they thought it was very funny that women would come into the workshop and some would be embarrassed or whatever. They just thought it was very funny. And that is obviously sexual harassment. But the employer didn't really think there was anything wrong with that. So that would be a classic example of sexual harassment. I worked at another workplace actually, it was an insurance company, and they perhaps went to the other extreme. They did, senior management did a walkthrough, big open plan call centre type setup. They did a walkthrough one day, and one of my friends was very upset because he was forced after that visit to take down his Kylie calendar. Senior management said, no, that is sexual harassment and your female colleagues might be offended by Kylie's semi-clad body. She was very upset about that. Victimisation. So this is where an employee suffers a detriment, basically because of something related to the Equality Act. So there are four things. So they bring a claim under the Equality Act and they're then subjected to a detriment, or they assist someone else or give evidence or give information to do with an Equality Act claim. They do anything else to do with the Equality Act, or they complain of the employer breaching the Equality Act. The most common way in which victimisation happens is where an employee brings a grievance and they're complaining about something that's covered by the Equality Act, and then as a result of that grievance they are subjected to some kind of detriment. So I would say probably the most common way that we see this in employment is usually employees brought some kind of grievance that such and such manager is harassing them. It might be some sex discrimination or sexual harassment. Manager turns around and says, well, this person's underperforming, going to put them through a performance management process, maybe a disciplinary process. And that's generally how we see these kind of victimisation claims happening. You've got a couple of things that are particular to disability. So under all protected characteristics, non-disability claims will fall under one of those four categories, and then with disability you've got the special added elements of failure to make reasonable adjustments, which everyone's very familiar with, the duty to make reasonable adjustments for someone who's covered under who has a disability. And then discrimination arising from disability, which replaced an old concept of disability-related discrimination. And it can be difficult to pinpoint what that means and how it differs from indirect discrimination. But to give you a practical example, if you had an employee who was visually impaired and it meant that their output wasn't as good as another employee, but they were put through a performance management process and perhaps even dismissed, that could be discrimination arising from disability if you can justify the treatment.
Some common pitfalls, making assumptions. So one common way that we see a lot where employers make assumptions is with right to work checks. So, and in fact I saw an employer describe this situation the other day when we asked the question, have you checked everyone's documents that they have the right to work? Oh no, we only checked it of our Italian employee, so we've got a copy of their passport, but we didn't bother with anyone else because they're British. Well, that's not only failing your right to work checks, but could be discrimination. That Italian employee could probably bring a discrimination claim. Sickness absence. If someone has less than 2 years service, obviously, and you want to dismiss them, obviously your first thought is great, they've got less than 2 years service, don't have to worry about unfair dismissal, we'll just get rid of them. But it's important to be very careful if there is sickness absence, just to make sure there isn't an underlying disability and you could be inadvertently discriminating against them. Doesn't mean you can't dismiss them, but just examine whether there is a disability there, and there might be some reasonable adjustments or something you need to take into account first. If there's performance issues, always have investigate that more and find out whether there's an underlying cause. Is there an illness that is classed as a disability that might be causing the performance issues? Is that person being bullied and harassed by a manager or a colleague on the grounds of a protected characteristic, and that's why they're underperforming? New mothers, another common issue that we see. Many new mothers returning to work want to work on a reduced basis, and dealing with those requests can create issues and pitfalls and problems, so another one to look out for. Part-time workers, there's specific legislation protecting part-time workers, but they would also be covered under the Equality Act. The majority of part-time workers are women, and therefore it's important to be careful about indirect discrimination where perhaps a PCP might disadvantage part-time workers. Consequences. The compensation is unlimited for discrimination claims. The tribunals will follow a set of guidelines known as Vento, and they'll split discrimination into 3 categories depending on how serious it is. So you've got a bottom, middle, top band, and generally all awards will fall somewhere in those Vento bands. And the bottom of the bottom is £660 and the top of the top is £33,000. And the median and average awards all fall within that. However, 2015-2016 tribunal statistics, the highest discrimination award made was £1.7 million. That was a sex discrimination claim. Next was disability, that was 257,000. I think race next at 45,000, religion 43, sexual orientation 20, and age bottomed out at £16,000. So those were the top discrimination awards in the latest statistics available. The top discrimination award ever was £19 million. That was a lady who worked for an asset management company as the head of legal affairs, who was subjected to an 18-month campaign of harassment. She had 2 sons with special needs, one with cerebral palsy, one with Asperger's. Her male counterpart was treated more favourably than her in terms of adjustments for dealing with her children. She was bullied, harassed, all sorts of issues. Ended up resigning her £140,000 a year job and suffered mental illness as a result of the treatment she was subjected to. They appealed that, and I think it went all the way to the Court of Appeal. It might have even gone further, but all the courts upheld the awards, and she did end up with a payout of around £19 million. So the word of warning is, although those sorts of awards are very rare, they are possible and they do happen. The tribunal also has the power to make a recommendation, which usually would happen, for example, if there was indirect discrimination and they said, employer, you have a particular practice that puts women at a disadvantage and we would recommend that you change that. The tribunal has no power to enforce a recommendation, so it's a pretty meaningless power, but there it is. Declaration, they can declare what both parties' rights are. Of course, tribunal action can result in reputational damage. It can damage morale internally with your existing employees, and it can damage your public reputation. Employment tribunal proceedings are public, so and particularly if it involves something sensational or high sums, it will make the news. It takes up a lot of management time. Anyone here who's been involved in a tribunal case will know the amount of time it takes up. And cost. Ultimately, even if you're successful and you've done nothing wrong, ultimately you will most likely end up still having to cover your own legal costs. So it's really important to get everything right in the first place, which of course everyone here does. Sure. My final thoughts, just to remind, the guide here does set out in here that direct, indirect harassment, victimisation descriptions in here, so I hope that's of some use. Coming up, gender pay gap reporting, so any businesses with over 250 employees will have to comply with the gender pay gap reporting requirements. So the first report will need to be by April next year. The government are encouraging employers to publish as soon as possible. So your snapshot date will be April this year. So any time from April this year, basically, you should have the data available to be able to create your report. Dave from our HR team has been working tirelessly on an amazing tool to help clients produce this report. It involves ridiculously complicated maths that neither of us could master, but we have a very intelligent accounts team who helped us with it. But very nice spreadsheet that Dave's been working on, and ultimately we'll be able to help you with pulling together all of your figures, pulling out all of the data that you have to report on, and then producing that lovely explanation that goes with it, so that if there are any discrepancies, we can help best explain that, because you will have to publish it on your website. Right to work checks is just a favourite topic of mine, because, as I say, it is one that I do see a lot, and the Home Office are massively cracking down on illegal working and right to work checks, and obviously with Brexit it's going to become more and more an important topic. And very finally, obviously I've been talking about the law, I'm a lawyer, that's what I do, but I'm sure everyone will agree that people are the most important asset to your business, and ultimately you want to do all these things correctly, not because that's what the law says and you don't want to end up paying millions of pounds compensation, but because that's the right thing to do, and ultimately you want a happy and collegiate workforce.